that in his account the money was deposited by X. Is it not Benami transaction? And as soon as it is proved that it is a Benami transaction, then every minister or the Revenue Secretary, Finance Secretary were saying that there is imprisonment for 7 years. And the person can be entitled for 7 years imprisonment. We are just talking about penalties and tax. But what about this imprisonment if the government imposes this Benami Property Act? I have also not read this act very well right now because of paucity of time. Only busy in this monetization and surveys and other things. But friends, please go and have a study of this act, deep study. Then you find that in future things are very difficult even for an ordinary businessman. As regards this 2,50,000 being deposited into the ladies account or any individual account we were discussing. In the first 2 lectures meeting at Goa and Agra, our Honorable Prime Minister told that the ladies can save this much amount since last so many years. So if they deposit, no question will be asked to them. I think all of us are aware of this statement of the Honorable Prime Minister. But now our Finance Secretary, Revenue Secretary are saying that even this amount they can investigate. So whom will you trust? And as a law is concerned, yes, it can be investigated. It is another thing that so number of crores of accounts is not possible to investigate. That is a different thing. But if only 1% of those accounts are inquired for and investigated, what will the position? Law is same whether the money is deposited in Jan Dhan account or in this ladies account or in your business account. It's very simple that you have to explain the source. Or section 115 BBE will be applied. So friends, I think in last 20 days or 22-3 days, so many discussions have been made on demonetization and already 75% of money have been deposited. Only 25% is pending. Those who have deposited and not as per law, they will be in trouble. Those who have not deposited, it's my advice that they should deposit only as per their cash balance. But even if you are having cash balance, there can be problem. Suppose you are having a cash balance of 3 crore, 2 crore rupees. The income tax department gets the information that the SSC has deposited 2 crore rupees. That time they do not know what is the status of the SSC. They will either conduct a survey, issue 131 and ask you to. Even it is disclosed, there can be problem. Or as your Jan Dhan account is concerned, it's only a political stunt because everyone is aware that money has been deposited into Jan Dhan account either by the politicians or by the terrorists, Naxalites or Maoists. But legal position is the same. Friends, now I come to my topic, statement FIU and section 131. This statement will also help the SSC if any demonetization notice is given to him, because under that process also they will record the statement. So this is also a relevant subject today. Yes. first so how the statement is recorded, this is very, very important thing to know, because every day our SSC, our clients get notices under various sections and the statements are recorded, but every section has its different significance, and the recording of statement procedure is a very, very vital thing to know. Normally, statement is recorded either during scrutiny assessment or during survey, during search, or now this demonetization period, which I have already referred. As regard statement during survey is concerned, survey is very common and statement is recorded without oath. During course of survey, statement is recorded under section 133A of the Income Tax Act, and that statement is recorded without oath. This statement has got no evidentiary value. If a statement is recorded under section 133A during course of survey, either by the assessing officer or by the investigation officer, it has got no evidentiary value. There are various case laws, including Supreme Court case, CIT versus S. Qadir Khan, Paul Matthew and Sons, Sunrise Tooling System. So those cases are very important, S. Qadir Khan and Paul Matthew. Suppose in course of survey, a statement is recorded and the SSC is asked to admit undischarged income to the tune of ₹1 crore. And he admits under pressure. He admits it and there is no supporting document. Then during course of assessment, if the assessing officer says that since you have admitted this income as your undisclosed income during course of survey and there is a statement, so I will make the addition. Even if you make the addition, that addition has got no value because the admission being made by the SSC was in statement under section 133A and which has got no evidentiary value. No addition can be made only on the basis of statement recorded under section 133A. Various times the assessing officer record statement during course of survey under section 133A, and the assessor thinks that he has to pay such much amount of tax. He should not be afraid. No tax can be charged. Even if the addition is made in the appeal, the assessor will get the relief. Statement during search. Statement on oath. The statement made during search is made under section 132 in bracket 4 of the Income Tax Act, and that is under oath. That is the vital difference between statement under section 133A and statement under section 132 in bracket 4. And in the beginning they asked to write that I am giving this statement under oath, and this statement is without any threat, caution, etc. It is signed by the SSC. Statement at the commencement of the search. As soon as the search commences, a preliminary statement is recorded. The officers, the investigation wing enters into residence or the office and records a preliminary statement. Some common questions are normally asked, but our clients should be aware of those questions. That is very simple. Identify yourself. What is your PAN number? Give details of your family members. What is your, as well as your family's source of income. So you must reply all these things as per your income tax returns. How much cash is lying in the premises? This question has some significance. Suppose a survey search is made in the residence and this question is asked, how much cash is lying in the premises. Normally, the question is asked to the main person of the group. Then, what should be the reply? If this question is asked that how much cash is lying in your residence, then what should be the reply? Suppose your clients ask you, then what we should advise him to reply on this question? It's a very simple question, but it has got some tricks.
I will count and then give.
Anyone friend?
Papu is chill.
Anyone friend? Normally, what happens, I have seen, as soon as this question is asked, the client or the assessee simply says 2 lakh rupees, 3 lakh rupees, 4 lakh rupees on estimation, or they may have some idea and they give this reply. This is not the correct reply. Why, friend? Suppose it is a big family, or even if it is not a big family, husband, wife and 2 children are there. We have seen in the demonetization, so much money was lying with the ladies. And the person is not aware how much cash is lying with his wife. ये पोल खुल गई इस बार. So friends, if he says that 2 lakh rupees, but if 5 lakh rupees are lying with his wife, then it will be a false statement. Because he has said that 2 lakh rupees are in the house, whereas there are 5 lakh rupees. So it is better to say that, sir, I have this much of amount, maybe 10,000, 50,000, whatever may be, but as other families members are concerned, I am not aware, so let me either ask them or then I can tell you. And he was also right in telling the let me count, they will not allow you to count, but your reply was more or less in that sense, never give that this much cash in and is free. If you are 100% sure, then only reply.
But is it always essential to know how much cash we do have in our house? We can always say like you count.
No, you count cannot be the reply. You can always say that I personally I am having this much amount, I don't know about my other family members, so let me ask and I will tell you. One thing more, have you any bank locker in your name? This is also a very common question. Sometimes they ask, sometimes they do not ask, but most of the searches they ask, how many, have you any bank locker in your name? Here be careful, because as soon as they will come to know about the bank locker, they will stop the operation. And suppose undisclosed jewelry is lying there, so you will be helpless. If the bank locker is in your name, you must admit that yes, I have one bank locker in such a bank. But suppose bank locker is not in your name, it is in the name of your wife or your son or your daughter-in-law, and in that case, and if you are also sure that bank locker's key is not in the house, then you can say, sir, I don't have any bank locker in my name. Because you are not giving any false statement. The question is that, have you any bank locker in your name? You can very well say, no sir, I don't have any bank locker in my name. If the later on it is detected that the bank locker is the name of the wife, and they ask you, you can very well say, sir, it is in the name of my wife. I don't have any bank locker.
But if it is in the second name, normally joint names are there. In locker, joint names are there.
Joint name. Then you have to admit. If it is in your name, joint name, you have to admit. Statement at the end of the search. At the end of the search, another statement is recorded. But there is a difference in the preliminary statement and the statement recorded at the end. In this statement, large number of questions are asked in respect of the documents found during course of search. So it is a very lengthy statement, and questions are also asked about valuables, cash, jewelry, etc. found in course of search. And you have to be very particular in reply all these queries, because statement is the basis. Even up to tribunal, it has got a lot of value that what did you reply at that time. Certain queries, in brief I can tell you, details of the family members, details of the immovable properties, these questions are asked, and details of the business activities, nature of business, details of various bank accounts, either in the personal name or in the name of the family or in the name of the companies and firms, these are asked. Name of the partnership firm, name of the company in which the person is director, all these questions are asked. And then they show you the seized documents found in course of search, and ask you to explain that what is written in the document, what is the meaning of the document or this particular entry. Such type of questions based on the seized documents are asked. Not only on the basis of the seized documents, but also on the basis of your transaction record in the books of accounts, the queries are raised. For example, if they find that the company in which you are director have raised capital of 5 crore rupees, even no document was found in respect of that transaction, that 5 crore capital. The investigating officer can ask that your company has raised this capital, what is the source, what are the document evidences, all these questions can be asked in course. You cannot say that this is in the books of account, so I am not obliged to give the reply. This cannot be a reply. Friends, I have already discussed a statement during demonetization period. Then one thing more, as far as this statement during demonetization period is concerned, whatever pressure they make, never admit that the money, the cash which had been given to X, who had deposited into his bank account, was given by you. The moment you admit, the banking, the Benami Transaction Act can apply. Prior to 1st November, it was a matter of only concealment and only penalty. So under any pressure, don't admit. Confessional statement. In 99% of the search cases or the survey cases, the officers create such pressure that our clients admits the undisclosed income. Sometimes even if the documents are not found to that extent, they even admit. Suppose the document related to only 5 crore income is found, but they ask to admit 10 crore, even the SSC sometimes admit that amount also. The CBDT has given so many circulars in last so many years. The last circular was in 10th March 2003 and the latest circular is 18 December 2014, in which they have categorically mentioned that as a confessional statement is concerned, the SSA should not be precise to give any confessional statement. And after this circular, for 1 year, in whole of the India, whenever the search took place, the investigating officer never forced to admit the undisclosed income, which we call disclosure of the income. But now they have again come in their old forum, keeping this circular aside, and they are in every search and survey, they are indirectly forcing to admit the undisclosed income. Guideline during recording of statement. Friends, how the statement is recorded and how we should reply. To answer all the queries to the best of knowledge, we should advise our client when we take him to the officer for statement that you have to reply every question to your best of the knowledge. If you have any doubt, then don't say that this is the reply. As I told you that how many cases you are having. If any doubt is there, then don't say this much amount. And the assessor should never refuse answer a question or issue related to the search operation. If any question is asked, you should never say, or the assessor should never say, I will not reply. The refusal is a offense and penalty of even 1 lakh rupees can be imposed for that. And you should not give any false statement. In support of his statement, the person should not provide false evidence, he is liable to be punished. If the officer asks for any evidence, then it should not be false in support of the statement, because it is also punishable under Indian Penal Code. There can be punishment, and the assessee has to have a signature in the statement. He cannot refuse. It is a duty to have a signature, and the reply should be made in full confidence. Because if there is a lack of confidence, then they will put so many questions that if any reply which you don't want to make, but under pressure you will make. So you should show your confidence, and the reply should be in brief. You just reply as much it is asked to you, not more than that. But there are certain person, if it is asked to them that where is the CSU building is situated, then they will tell the entire history and entire road map. So that is not required. So what is your name? Yeah. No. Up. Yes. What is your name?
My name.
Ah. I asked you what is your name, not your title.
But title is my name.
I know. Just telling you, for example purpose, I asked you the name, you told name and title. Same way, if they ask, only reply to that, not more than that. The reply should be made after understanding the query. It is also our habit, friend, whenever a query is asked, we are very much eager to show our knowledge. And before the query is finished, we just start replying. We show our smartness that we are aware. But at the time of recording of statement, don't show your smartness. Become a buddhu. It will be better. How? Because without listening to him, if you reply, the reply can be wrong. I'll give one example. And it's not a joke, it is a real example. After a search, after 2-3 days of the search, and it is a system that I took my client to the additional DI. It is called courtesy visit. So I just took him to him and told him that you should be very humble. And he just can't मान ली उसने इस बात को. And the additional DI told him several things, that you do this thing, you don't do this thing, all this thing. And for every question, every comment, he just used to tell, yes sir. After 15, 20, 30 questions, he just told, yes sir, nothing else. And very politely. And he was irritated. And in the same way, he told, am I a fool? He told, yes sir. Sir, this is the fact, friends. And he was annoyed. What you are saying? Then I just told him, sir, he was so humble, he was just replying to your every question, yes sir, he didn't listen. So please don't annoy. So that is what I am telling you. Without listening, if you are replying, such thing can happen. And one thing more, friend, before replying, suppose you want to take some time for replying the question. You take time. You can say, sir, what did you tell? I could not listen. then he will again repeat. By the time you get the time to rethink and can you make reply. Sometimes you can say, sir, I did not understand. There is a difference in did not listen and did not understand. Then he will again repeat his question. And there are certain questions where you want to buck and you don't want to give reply. But you cannot say, I will not reply, as I told you. Then you can say, I do not know or I do not remember. These two sentences are very common and most of my friends may be knowing. But one thing is there again, that these two sentences should also be used properly. A question was asked to a person whom also I have told that if you don't know, you can say, I do not remember, I do not know. But हम लोग जितना पढ़ा के जाते हैं उतना लोग ध्यान नहीं देते. Then the DDI asked him, what is your father's name? I do not know. Friends, I do not know and I do not remember. This also you have to use very technically. Retraction of statement. The statement given can be retracted, whether it is under section 131 or under section 133A or under section 132 subsection 4. While presenting the statement under two sections only, I did not touch 131 because there is a separate subject for 131. So while delivering, I will touch 131 section as regards statement is concerned. So these are important Supreme Court cases which says that the statement can be retracted. There is nothing illegal if you retract the statement. There is no bar in retracting the statement. Although there are certain conditions, it is not that every statement you can retract it or only because you have retracted the statement, the department will admit. It is not so. But yes, the statement can be retracted. And what are the conditions where the statement can be retracted, I will take up later on. Yes, condition for retraction of statement. Under these conditions, if a statement is retracted, it has got some value. The court will accept such retraction. Threat and coercion. If the statement is recorded under threat and coercion, it can be retracted. Although we have to prove the threat and the coercion. No corroborative evidence. If there is no corroborative evidence, as I told you, that suppose they have asked you to declare 1 crore rupees, but as regards the documents are concerned which have been seized, even after working, only it is found that only 50 lakh rupees can be worked out undischarged income. So there is no documents for rest of the 50 lakh rupees. This statement can be retracted because there is no corroborative evidence. Any statement without any corroborative evidence has no value. It can be retracted and it can be accepted by any court of law. Time limit for retraction. That is a very, very vital question. After every search, whenever a statement of the assessor is recorded and he has admitted the income more than he accepted, then the question arises with how should I retract it? The problem is that as regards the court cases are concerned, retraction should be made as early as possible. Either no time limit has been given, but as early as possible. But normally we don't advise to retract within 2-3 days of the statement record. Because as soon as you retract, they will again issue notice and they will again record the statement. And they will be furious. So as an investing wing is concerned, no one wants to annoy them. Then what is the position? Because after 2-3 months, after 120 days, maybe more, they will send the file to the central circle. By that time, they can issue notice any time. So how can you retract? So normally, we advise to make retraction at the time of assessment. But by the time it is too late, and there are various case laws which say that if there is a considerable delay in the detection, it will not be admitted. We can do one thing, friend, it can help us. I don't say that it will help, but it can help us. That during course of search, till the appraisal report, they don't give the copy of the statement. Because copy of the statement is only given if it is used against you. And that is used only at the assessment stage. So you just give a copy, give a letter to the DDI or the ADI that please give us the copy of the statement. He will not give. You just put one more reminder after 2 months. Your work is over. As soon as the file is transferred to the central circuit, you again ask him to give the copy of the statement and he will immediately give the copy of the statement. Before you write this letter to the assessing officer for copy of the statement, you prepare all the affidavits and the documents which you want to file for detection of the statement. And today you get the copy of the statement, tomorrow you file the detection statement. You can at least argue in the appeal that since you did not have the copy of the statement and in spite of asking for the copy of the statement you did not get it, how could you detect it earlier? And as soon as you got the statement, you have detected it. So where is the delay? And there are certain cases.
What is the procedure for retraction?
Affidavit has to be made and you have to mention the facts that in what condition the statement was recorded, and the copy of the original affidavit should be filed before the assessing officer or the investigating officer where you want to file. Statement in odd hours. If the statement is recorded in odd hours, means midnight, and if it can be proved, then the statement recorded can be detected or the statement can't be relied upon by the higher authorities. The department cannot disturb the sleep of the assessee. From after 12 o'clock to 4 o'clock or 5 o'clock, if you ask that you want to sleep, they will have to allow you to sleep. But if they record the statement during that time, previously it was a habit. Most of the statements during the search were recorded in midnight. But now they are also careful. They also allow the assessee to sleep and they record in the morning. But if any officer is recording, don't stop him. Let him record. It can be helpful for you in arguing that it was recorded in odd hours, so it has got no value. Cross-examination. A statement is given by Mr. A that he has given accommodation entry to B. The statement was recorded by the assessing officer or by the DDI. Then a copy of it was sent to the B that A has given you the accommodation entry, so it will be added in your file. Suppose this is the situation. Now B can ask the assessing officer that please allow me to cross-examine A because his statement was recorded at my back. I was not aware what he has told. You have recorded his statement and he is your witness, so I want to cross-examine. This is a good weapon in the hands of the assessee, and there are number of case laws in which the court has stated that if the opportunity of cross-examination is not given, then even the assessment can be nullified or it can be even set aside. These are certain case laws on all these issues. State and coercion, then corroborative evidences, statement record without corroborative evidences, time limit. This Radhesham Agarwal case law, ITT Kalkana is important as far as time limit is concerned, and statement in odd hours. This CCIT versus Rajendra Singh, I have not been able to give the citation, but it is a Patna High Court case. You can note down. And as far as cross-examination is concerned, there are Supreme Court cases, Dhakeshe Cotton Mills versus CIT and Kishan Chand Chelaram versus CIT. The apex clause told that opportunity of cross-examination must be given to the SSC. Friends, as far as the statement is concerned, I have touched some practical aspects, how it is given, how it is recorded, and how we should apply. Now I come to section 131, which I did not touch because statement is also recorded under section 131. And this is the very common section under which statement is recorded. I think everyone present here knows what is section 131. Section 131 gives power to the tax authorities to issue summons or to force attendance of the person for being examined on oath, or to compel him to produce the books of accounts and other documents if any proceeding is pending. So a person has to appear in person and he has to produce the books of accounts or the other details as asked for in the notice under section 131. Friends, you see that section 131 and section 131A, there is a difference in section 131 and section 131A. Section 131, where notice is issued by the assessing officer, and section 131A, where the notice is issued by the officer of the investigation wing above the inspectors, either ADI, DDI, additional DI, DI, DG, etc. And section 131, assessing officer or JCDI, CIT, etc. This is the basic difference between the two notices. And second difference, which is very important, that notice under section 131 can be issued if any proceeding is pending. But notice under section 131A can be issued even if no proceeding is pending. What do you mean by pendency of proceeding? Suppose a assessment is going on. Now assessment time barring on 31st December, so it is already under process. If the assessing officer wants to examine any person as witness, suppose X has given loan to your SSC, he can issue notice under section 131 to examine X because proceeding is pending. But if the order is passed on 31st December and he has forgotten to examine the loan creditor, he cannot issue notice under section 131 after the assessment order is passed because no proceeding is pending. And 131A, this is their sweet desire, anytime, anywhere they can issue notice under section 131. It doesn't require any pendency or proceeding. This difference we should have in our mind. And notice under section 131 is issued, 131 or 131A, to the SSC as well as to the witness. SSC means whose assessment is going on, and witness means, as I told you, the loan creditor. He is the witness. If the notice is issued to the witness, or if the notice is issued to the SSC, in both the circumstances, can we represent? We are offered a representative, and can we represent both the cases if the notice is on the witness or if the notice is on the SSC? What is the difference? Yes?
So on witness, I think we can represent.
No, friend. We cannot represent the witness. We can represent the SSC, but not the witness. How? Suppose a murder has taken place. You are the witness. Can you say someone other, yes, on my behalf I am sending him, he will explain what happened. It can't be. Likewise, in case of SSC, you can appear, but in the case of witness, only the witness. That is why you see, they always mention that person in appearance, personal appearance. And we always say that in every notice they ask for the personal appearance. But in case of witness, they are rightly mentioning that personal appearance. Non-compliance to notice under section 131 or 131 penalty, there is a penalty of 10,000 rupees for non-compliance. There is a prosecution also, and it can lead to survey, and sometimes it can lead to search. Very rarely, but survey is very common. If the investigating is issuing notice and asking you to appear twice or thrice, if the SSC doesn't appear, they can conduct survey.
But sir, if witness doesn't appear, then can he be surveyed?
Of course, as regards 131 is concerned, the assessing officer cannot conduct survey on the witness. He has no jurisdiction. He can conduct survey only on his SSC. But as regard 131A is concerned, investigation wing can very well conduct survey if the witness doesn't appear. And not very well. Regularly they are conducting survey for non-appearance by the witness. In whom to be served, I have told personal offence, incomplete notice. If a notice is incomplete, then statement recorded under such notice has got no value. Some strike off, some portion is strike off, some portion is retained. It should be a perfect notice. There are certain cases also. Nature and purpose of notice should be mentioned. Pending question I have covered. Notice after conclusion of survey and notice after conclusion of search. It's an important thing to know. There are different cases as well, that whether after conclusion of search, notice under section 131A can be issued or not. What is conclusion of search? Search is concluded within 2 months of the last Panchanama. And suppose there is no last Panchanama, on the date of search, everything was over, there is no locker, anything, then whether they can ask you to appear by issuing notice under section 131A because the search is concluded. Or after 2 months when search is concluded, whether they can ask you to appear during course of this appraisal report proceeding. Different high courts say different thing, but as a convention, as a system, they are regularly issuing notice under section 131A whether search is concluded or not. But notice after conclusion of survey, here there is one point. In every survey, you must have noticed that they issue notice under section 131 at the end to appear next day. Why? Because if notice under section 131 is not issued on that day, the survey proceeding is over. As soon as the department leaves your premises, the survey proceeding is over. So department cannot issue notice under section 131 because no proceeding is pending. But friend, what they are doing now, that in every survey they are issuing notice under section 131. Second thing, notice under section 131 can be issued only if the SSC is non-cooperating. If there is non-cooperation from the SSC, only under that circumstance notice under section 131 can be issued and statement can be recorded. Otherwise, statement has to be recorded under section 133A. Only up to 1 year back, they were not issuing 131 for the purpose of recording of the statement. They used to record the statement under section 133A on the date of survey. But since last 1 year, in every survey proceeding, they are recording statement under section 131 because they are well aware that the inventory value of this statement under section 133A is not much, or there is no inventory value at all. Although this notice has not been challenged in the High Court, but it is my personal view that if the department doesn't mention in the order sheet that the SSE has non-cooperated, and that is why the notice under section 131 has been issued, if we have not mentioned anything like this, then if you challenge in the High Court, that notice can be questioned. These are certain case laws for personal appearance. Incomplete notice, as I referred, pending proceeding, and notice after conclusion of search. One is and notice after conclusion of survey. This Vijay Pava versus Samir Mukhopadhyay, last case law. Some of you might be knowing the name of Samir Mukhopadhyay. He issued 131 just as the survey proceeding commenced. Within 15 minutes, issued notice under section 131. The proceeding was challenged in the High Court. The Calcutta High Court told that there was no sign of non-cooperation because survey just started. So this notice was bad in law. So friends, now I come to FIU. Time is very short. FIU, the full form is Financial Intelligence Unit. What is this? Nowadays it is very, very important to know about this FIU. This is situated in Delhi, and the banks across the country are sending information to the RBI as regards the suspected transaction in the particular bank accounts. And the RBI then sends those information to FIU. After getting those information, FIU makes its own investigation, own inquiry, and then with that report, they send it to the respective DDI. Suppose the SSC belongs to Calcutta, they send this to DDI of Calcutta. If it belongs to Bombay, they send it to the DDI of Bombay. Then the DDI transfer it to the respective DDI for further investigation. The search or the survey nowadays are the main reason for the outcome of such FIU investigation. After getting such information, the DDI makes his own investigation by sending notice to the bankers or to the others and collect certain information. And then they also issue notice to the respective persons. Suppose a detail of bank account is sent to the DDI. Here he finds that cash is deposited every year and then check is given. Or there are always a transfer checks. A check has been received today and today it has been transferred. Again, next day the check again transferred. Such type of transactions are called suspicious transaction. Then the DDI will look that where the check has gone ultimately. You must be knowing about the sale of shares, checks, etc. So from one account, ultimately they got